We began, everybody, tonight with a man wrongly convicted of murder walking out of prison today.
New evidence has cleared Mark Maxson of a murder that occurred more than 20 years ago. He was serving a life sentence at Stateville Prison near Joliet. Eyewitness News reporter Evelyn Holmes was there when Maxson walked out. Evelyn?
Well, Mark Maxson has been free for just about over an hour now. After years of professing his innocence, it is new DNA evidence that finally freed him. After spending nearly half of his life in prison for a crime he says he didn't commit, Mark Maxson is finally a free man.
That's the best feeling that I could have, because my mother was there, the only, my mother's my stability.
The elated 55-year-old smiled as he walked out of the Stateville Correctional Center near Joliet this afternoon, only hours after a Cook County judge threw out his conviction for the murder of a 6-year-old boy on Chicago's South Side.
I wasn't going to give up on him.
No.
And I did what I could.
Maxson was sentenced to life in prison for the 1992 slaying of first grader Lindsay Murdoch. Investigators focused in on Maxson after he told a TV reporter that he'd bought chips for the child and told him to go home. The boy was found dead the next day in an abandoned garage near 107th and State. In a statement, a spokesperson for the Cook County State's Attorney, Anita Alvarez, writes that after an exhaustive reinvestigation, the conviction of Mr. Maxson could not stand. A criminal investigation into the 1992 murder of 6-year-old Lindsay Murdoch remains ongoing.
This case stunk right from the get-go. The judge said the same thing.
No physical evidence ever linked Maxson to the crime. Maxson has always maintained his innocence despite his confession, which attorneys say was coerced by detectives working for the infamous Chicago Police Commander John Burge.
He succumbed to the psychological torture.
Mark Maxson is the 15th person to have his conviction vacated since State's Attorney's Conviction Integrity Unit was formed in 2012.
I tell brothers to stay focused on, stay strong, foundate yourself on the facts of your case.
Now, Mark Maxson went to a steak dinner with his mother. He says then he'll go home and take a little time to figure out what he's going to do with his new future. Reporting live from Stateville Correctional Center here near Joliet, Evelyn Holmes, ABC 7 Eyewitness News.
Our next speaker is Dr. Wallace Gator Bradley.
Yes, good morning, Chairman.
Good morning.
Since 2016, I've been speaking about the wrongful conviction of Mark Maxson. But I've been fighting for him to be free since 2013. And I'm speaking as an ex-felon that received a pardon, that did my bit in Stateville, and by God's mercy and grace, I was allowed to go back behind the wall of Stateville to help bring this man out. I'm glad to see that it's on the finance agenda, that he's going to receive a settlement for $8,750,000. But I'm going to share this with you. Because I fight him, and I do it all the time. And the one thing about it is freedom from being wrongfully convicted for a case outweigh the value of the settlement. You know what I'm talking about. You've been locked up 23 hours, 23 days, 23 years. His freedom. Sometimes an individual got to accept a blessing that God given when he gave him 2 blessings. Had I been locked up and had I been freed, I would have been happy to have a SSI check. But because October 22nd, this body or the corporate counsel made a decision to stop paying them private attorneys. From 2016, they have paid them private attorneys $2,700,000 for a case they knew that they couldn't win. Just one case and a bunch of them coming. I just want to say, I hope this body agreed to this settlement There's all the settlements that's on here. But I want to thank you, if you do, for Mark Maxon, because I realize that the struggles that God had gave me to fight ain't been in vain, because this ain't the first one that I brought to get this done. So I'll just say thank you. I hope y'all agree with this to be brought before the full council, and stop paying them lawyers that cannot win a case because of torture and wrongful conviction. Again, thank you.
Mark Maxon versus John Duffy et al. The Department of Law recommends settling this reverse conviction lawsuit for $8.75 million. Plaintiff Mark Maxon was convicted in 1994 of sexual assault and murder. His conviction was vacated in 2016 after DNA testing conducted on a sample from the victim's clothes revealed that that sample did not match Maxon, and when compared to law enforcement database, it was discovered that the DNA matched another man named Osborne Wade, who had been previously convicted of another murder. Following his conviction being vacated, Maxon was awarded a certificate of innocence. He brought this suit against former detectives John Duffy, Angelo Pesavento, and William Marley, alleging that they coerced Maxon's confession, fabricated evidence, withheld exculpatory evidence, and maliciously prosecuted him. In addition, Maxon brings a Monell claim against the city, which is stayed while the other claims proceed. At this point in the litigation, discovery has ended, and the next stage would be summary judgment if the settlement is not approved by this body. The underlying crime here is a horrific murder and a sexual assault of a 6-year-old named Lindsay Murdoch. Lindsay went missing on the evening of August 29, 1992. His body was found covered in debris in an abandoned garage at 10730 South State Street. Media covered the incident, and Maxon, who lived in the neighborhood, was interviewed by reporters on television. Maxon told reporters that he had been with the young boy the night that the boy disappeared. Officers saw the interview, and Maxon was the last person known to have interacted with Lindsay. Detectives also discovered Maxon had been previously convicted of raping a woman in 1981. The officers reached out to Maxon, who agreed to come in for questioning. Maxon initially stated that he ran into Lindsay, who was alone on the street, at around 10:30 p.m., and he bought Lindsay chips at a liquor store and told Lindsay to go home. Then they parted ways. Maxon remained at the station overnight until he was taken for a polygraph. He claims that he was detained against his will. The officers contend that he remained voluntarily. The officers told Maxon that his polygraph indicated deception. Maxon was then re-interviewed and taken for blood samples. He remained at the station again overnight. The next day, he was again interviewed by detectives who reported that Maxon admitted then that he had bought crack before he ran into Lindsay. He said that he went to smoke crack in the abandoned garage, and Lindsay followed. Maxon then stated that he sexually assaulted the boy and choked him, then hid the body in the corner of the garage. Maxon repeated his confession to the assistant state's attorneys and gave a court-reported statement. Maxon, however, refused to sign the statement. At that time, blood and hairs were recovered, but none of it matched Maxon. No DNA testing was conducted because this was 1992. Maxon was tried and convicted by a jury in March 1994. He was spared the death penalty and sentenced to life without parole. Years later, Maxon petitioned for DNA testing, which was granted in 2016. As I stated, that testing revealed that the DNA did not match Maxon and that the DNA matched Osborne Wade. Maxon was released after the testing revealed that and charges dismissed. Wade was prosecuted and he pled guilty in 2021, but only to the charge of attempted murder. Maxon claims that his conviction was based solely on his confession, which was physically and psychologically coerced from him after he was unlawfully detained for 60 hours. He claims that the polygraph results were false and that the officers rushed to judgment in this high-profile crime. Maxon was in prison for a total of 24 years, and he will likely ask a jury for at least $48 million at trial. That does not include possible plaintiff's attorney's fees that the city must pay if Maxon wins, which will likely be around $2 to $3 million. The parties participated in a settlement conference and were able to reach an agreement for $8.75 million pending this body's approval. For all these reasons, the Department of Law recommends this settlement as fiscally prudent.
Thank you very much, Ms. Felker. Alderman Mitz.
A child, what was the age?
6 years old.
6 years old? And where were the child location? What was the location?
The body was found at 10073 South State Street at an abandoned garage.
And this was at 10 at night, 10 p.m.?
So he went missing on the evening of August 29th, 1992. Maxon ran into the boy at 10:30 p.m.
And there was a history of sexual assault from Maxon previous?
Maxon had been convicted of rape in 1981.
And he was, what was with that case? What was he dismissed? Was that case dismissed and he was out?
The 1981 case?
Yes.
No, he
Was on
remains
probation?
convicted of that. To be clear, he's not in prison, but his conviction stands.
Okay.
Anything else, Alderman Mitz?
I'm just mind boggled. What was that parents, relative, family members? I just want to know, 6 years old, 10 o'clock at night.
All right,
That's all.
got you.
Thank you.
Alderman
Thank you.
Spizzato?
Madam Chair, thank you, Jessica. Question about Osborne Wade. So he's serving life in prison now? Because did we pursue any charges against him, or is he like 20 years, or what's the deal with him?
He's been convicted. He pled guilty. I don't know his full sentence. He pled guilty to attempted murder.
But he is in prison. So then my question would be, one, why wouldn't we make sure he never gets out of prison by prosecuting him for that? And two, was Maxon and Wade, were they buddies or anything like that? Is there any association between those two?
So Mr. Wade is in prison. He was convicted of this as an attempted murder. So he's been pursued as charges as soon as they discovered the DNA. As far as whether we have established a relationship between Maxon and Wade, other than being from the same area, no.
Thank you. Thank you, Madam Chair.
Thank you. Ms. Felker, the DNA, the autopsy, did it reveal sexual assault on the young child? And if so, was the DNA testing done from the sexual assault?
Without getting into too many of the gory details, there was evidence of sexual assault. No semen was recovered. So there was no DNA testing to do.
Okay. Any other questions? Is there a motion to recommend approval of item number 5E? So moved by Alderman Mitz, recommending do pass. All those in favor of the motion signify by saying aye. Opposed? In the opinion of the chair, the ayes have it, and the do pass recommendation will report it out at the next city council meeting.